Talk Shoes.
Recorded live.
Hello, ladies and gentlemen. We're back on again. Got Volume 3 with the Dick Act of 1902. There's a lot of stuff that's happening out here with our own system, trying to pass gun laws. I'm here to let you know that the Dick Act has never been repealed, and it cannot be repealed. And that this guarantees you your right to any type of arm that you want. I didn't say weapons. I didn't say firearms. I said arms. Understand the word difference in phrasing of what we're talking about here. Because, ladies and gentlemen, this is very significant. Very significant of what we are running into an issue is that they cannot regulate what you and I own or what you and I have or however many. As long as you paid for them, and you don't have to sit here and keep records because they already have the records whenever you bought them. And the bottom line is you can buy them off anybody, and that is how it works. I want to bring up some stuff. I'm going to sit here and I'm going to bring it up to you. The Dick Act of 1903, under House Resolution 1165-4, comes back in and starts out with the basis here. It puts a lot of restrictions on their side of the fence. The Dick Act of 1902, also known as the Efficiency of Militia Bill, H.R. 1165-4, June 28, 1902, invalidates all so-called gun control laws. It also divides the militia into three distinct separate entities. That 1968 gun law that got passed in 1968, this invalidates it. The three classes under H.R. 1165-4 provides for are the organized militia, henceforth known as the National Guard of the State, Territory, and District of Columbia, the unorganized militia, and the regular army. The militia encompasses every able-bodied male between the age of 18 and 45, but it does go up higher than that because you've got military officers higher than that, and it now comes into discrimination. All members of the unorganized militia are to have the absolute personal right to the Second Amendment to keep and bear arms of any type, and as many as they can afford to buy. Don't say you have to have a receipt. You can afford to buy them, you're entitled. If it costs you $1, costs you a penny, you're buying them, you can have them. The Dick Act of 1902 cannot be repealed. To do so would violate the bills of attainder and ex post facto laws, which be yet another gross violation of the United States Constitution and the Bill of Rights. The President of the United States has zero authority without violating the Constitution to call the National Guard to serve outside of the borders. That also gives him zero authorities to regulate the ability to own certain arms like AKs, ARs. He has no authority, and Biden don't have any authority to go out and say, well, we're going to ban. No, you don't have the right to ban these. You don't have that authority. This will violate the Constitution and violate the Bill of Attainder. But, ladies and gentlemen, this law is in full force and effect. It has been since 1902. For those of you that wonder, it falls back under statute at large, under Volume 32, under statute at large. It's Public Law 33. Chapter 196, under Volume 33, Volume 30, Public Law 33. Ladies and gentlemen, we have an absolute right to a Second Amendment. You do not have to have a gun permit. You do not have to have permission. Problem of it is, how many of you are going to sit here and fight this? How many of you are willing to stand up and stand your ground on this? This is just like a driver's license issue. ATF. Whoops. Is that another administrative agency, an ATF? Is this another administrative agency that's regulating your ability and to be able to own anything? Doesn't this fall back under the Public Law 148 Stat 1 state of emergency, where they turn around and the president gave agencies the authority to regulate? Isn't ATF an agency? Aren't they trying to regulate you? Isn't it an administrative agent that's dragging you in? Isn't this supposed to be an administrative court? Aren't you supposed to be an employee? This regulation goes back on the police officers. It goes back on the sheriffs. It goes back on law enforcement. It does not come back in. Because remember what we said here. A well-regulated militia, National Guard, unorganized, and the military. It does not use the word law enforcement. It does not give law enforcement the right to carry anything. They're not militia. They're not supposed to be a military force, because that's not what they're calling them. They're calling them police department. They're calling law enforcement. They're not calling them military. They're not calling them militia. What authority does a police officer have to have an AR-15 fully automatic or anything else out here? What gives them the right to even carry a firearm? What allows them the right to carry a pistol? Stop and think about what I'm saying here, ladies and gentlemen. I'm not the one that wrote these laws and rules and regulations up. It goes right back into their side. These are their public laws. They created it. There's nothing in the laws that give law enforcement the ability to pack any type of pistol, shotgun, or rifle, AR-15, or anything else. There's nothing in the regs that allows them to carry. They took it upon themselves. The lawyers gave it. The judges took it upon themselves to arm their own personal army against the civilian population in violation of the Labor Code. Think about what we're getting into here for a debate. Think about what we're getting in here for a argument with these people. These people don't have the right to come into your house and take your stuff out of your house. That is not within their regulations and not within their rights, and they are in violation of public law. They do not have the authority to come in and do. On Thursday, October 4th, 1917, Mr. Gordon, Mr. Speaker, on page 6,836 to 6,040, 6,840 of the Congressional Records of September 10th, 1917, the address of Charles E. Hughes delivered to an annual meeting in the American Bar Association is printed. In the address, Mr. Hughes says the militia within the means of these provisions of the Constitution is distinct from the Army of the United States. Remember always, said Daniel Webster, that the great principle of the Constitution on that subject is that the militia is the militia of the state and not of the general government. And thus being the militia of the states, there is no part of the Constitution worded with greater care and more scrupulous jealousy than that was granted when limited the powers of Congress over it. Mr. Hughes then continued, in order to execute the laws of the Union to suppress insurrection and rebellion, invasion, it would be necessary to employ regular troops or to employ the militia, and the power given to Congress with respect to militia was manifested to make a large standing army unnecessary. But as the service of the organized militia can only be required by the national government, for the limited purpose specified in the Constitution, it follows. The Attorney General Wickerman advised President Taft that the organized militia, such as cannot be employed for offensive wartime outside of the limit of the United States. By his own admission and by the citing of Daniel Webster's and the opinion of the Attorney General Wickerman, Mr. Hughes effectively disproved and discredited the very points he attempted to establish, to wit, that the drafting of the militia or any part of it, these men can be divested of the protection with the Constitution of the United States, throwing around them by limiting the use within the federal government may make of the militia, suppressing insurrection, rebellion, and invasion, and executing the laws of the United States. The militia, not police department, not law enforcement, the militia is supposed to be enforcing the laws of the United States. There's nothing in here that allows law enforcement. That now becomes a private army. That is private arming. And it is the militia that is to enforce the laws. I'm not saying it. It's right here in the paperwork. Right here in the paperwork. The militia was set up for accountability. The militia was set up for the Labor Code to come into these public offices to ensure that these people would not violate the people's rights. And if they did, they got caught, that militia, the commander of that militia was supposed to take them out, and under the Labor Code was to execute them immediately. This isn't me saying it. This is what is written by their side. These are their written words, not yours and not mine. This was created by the Bar Association, which is the barristry, the lawyers, the Communist Party. They are the ones that wrote this up, not you and I. We are not supposed to have law enforcement. It's supposed to be militia out here enforcing it. And your police department are not militia, because they're under the control of the judges, not under the control of the military. The militia is in control of the adjutant general, not the local judge. Now stop and think about what I'm telling you people out here. Comprehend what's being said. The term militia, as used in the Constitution of the United States, include every able-bodied male citizen capable of bearing arms, and those have been further defined by the statutes of the United States and acted since the adoption of the Constitution, as all males captive of bearing arms between the age of 18 and 45. That was back at that time period. After the War of 1812, with England had been progressed by 2.5 years, and attempting was made to Congress to pass the bill authorizing the President to draft but lot the use between age and 45 years of 100,000 men, with whom he proposed the invasion of Canada, the enemy territory. But ladies and gentlemen, your law enforcement is your militia, not your local police department, not your local sheriff department. Your law enforcement comes from militia, your unorganized militia, your National Guard. These are the ones who are supposed to be enforcing the laws of this country. And they don't come under the jurisdiction of the Bar Association, and they don't come under the jurisdiction of the local judge. That Dick Act of 1902 cannot be repealed. It invalidates all gun laws, including the 1968, including the bans on what they call assault rifles. There is no ban. And the sooner you people could understand the Dick Act, and it's like everything else, this falls back under an administrative agency, which is the president, that is trying to regulate your right to a Second Amendment. You have absolute authority to own whatever you want to own, and own however much, as long as you're paying for them, and it doesn't give a dollar amount. It doesn't matter whether you traded for it. They can't come in, oh, you got 40 arms in here. You got 40 weapons, so we have to, you don't have the right to confiscate squat. Number one, you are a police department, and there is no authorization in the Constitution, and there is no authorization in the Militia Act that allows the law enforcement to be created. Now, this is something that none of you people ever gave any thought to. This is something you never sit down and gave one iota, but yet I'm sitting here broadcasting it out to you, and I'm reading the congressional records that come back in and backs this stuff up. There's no place out here that allows law enforcement. This is a private standing army created by the Bar Association. This comes up to the American people to determine what's right and what's wrong. Now, hold on a minute. Yeah, I think get up, get something out. We got TV dinners, whatever. Soup, don't throw anything other than soup. Soup's fine. All right. But, ladies and gentlemen, again, this isn't me saying it. We're going back into their own congressional records. We're going back into their own terminology. They cannot, without violating the Second Amendment, Bill of Attainder, and ex pro facto laws back, they cannot disarm the American people. If you choose to give it up, that's your choice. And I realize a lot of you out here on so much of this stuff that's going on in this country, ladies and gentlemen, something you may have not gave any thought about is that this stuff may be set up through government sleeper cells where they have come in and they've created an incident. They have hypnotized people to come out at certain times to create an order to create a problem. It goes right back into wag that dog. Let's go create an issue, get something off the president. Let's go create an incident, because there's more and more stuff coming out about this Connecticut issue. The problem of it is this. Our system has lied to us on everything. And if they was to start telling us the truth, we wouldn't be able to believe them anyhow, because they've lied. But ladies and gentlemen, we're sitting on the documentation. I'm telling you where it's at, the 1902 Dick Act. We're sitting on the congressional records on all this, of what we're talking about. This one comes under. Let me pull it back up here. There's a whole file on the Dick Act that I have that clearly comes back and shows they cannot disarm the American people. They don't have the authority. They don't have the right. They don't have anything that they could come back in and do to justify anything that they're doing. Okay, it was in the 1917 congressional record. Let me pull up the heading of this thing. Yep, congressional records on the Senate, September 10th, 1917. Starts out on 6836 and goes over to 6840. It talks about the 1902 Dick Act. This was done in 1917. But ladies and gentlemen, do not be played as a fool. Do not sit there and allow them to come in and regulate you on what you can have and what you cannot have, and come in and raid, because this is a direct violation. And I'm going to remind you people of the word firearm. For those who have not heard this, I want you to look into Title 27 CFR. Title 27 CFR, Code of Federal Regulations. I want you to look under 479.11. Definition of the word firearm. That is Title 27 CFR 479.11. I also want you to get into Title 26 USC Code 5845. A firearm is a modified shotgun of a barrel of 18 inches or less, overall length less than 26 inches. A modified rifle of a barrel of 18 inches or less than 26 inches. A fully automatic machine gun and a silencer. These are what is classified as a firearm. Then they have other titles of destructive devices and rifles and pistols, but they have them separated for what they are. But the only thing that is listed as a firearm is four entities: a modified shotgun, modified rifle, a fully automatic machine gun, and a silencer. These are your firearms. But you know what? The Dick Act 1902 blows that right out the window, because under the Dick Act, you can have these. Oops. You weren't supposed to know that. Ladies and gentlemen, we've been lied to, shanghaied, and bamboozled by the system so bad, by the Bar Association, by the lawyers. Your lawyers won't bring any of this stuff up. Your judges will suppress this. Because if this ever gets out and people really start understanding this, like they would the bankruptcy of 1933 and that Federal Reserve Act of 1913, where the Federal Reserve notes are strictly internal, strictly for the banks alone, and you are not to have any of them in your pocket. If you really understood this and the system understood that you understood it, ladies and gentlemen, there would be an uprising in this country. There would be a civil war. There would not be a lawyer or a judge out here that would be in this country. If you people really, truly would start pulling your head out of your butt and understanding the simplicity and how simple this stuff really, truly is, and learn how to argue it and how to stand your ground, there is no place in any of these laws that allows the police department to even come back in effect. There's only one place, and it's in the Constitution, that dealt with the sheriff. But that is for prisons. That's for prisons. That's for protection in the courts. They don't have the arresting authority out here. They're to serve papers on you. But there's nothing out here that allows the police department to be formed. It is strictly militia that is supposed to be enforcing the laws. And that comes under the Adjutant General. Ladies and gentlemen, start getting a grasp of what we're talking about. Start getting a comprehension of what we're talking about. Start understanding their written regulations, their written laws, their written intent. Start understanding the significance. That Dick Act of 1902, ladies and gentlemen, this is the biggest thing that we have coming in as the private attorney general and bounty hunter. This is in the same significant area. Like I said, there's no place in the laws that we come across that allows for law enforcement. Your militia is supposed to be your law enforcement. You and I are militia. You and I are unorganized. You and I are the enforcement. Whoops, what did I sit here and tell you? You and I are the enforcement? You and I are militia. You and I are the unorganized. You and I are the enforcement. But we're not organized. Even though we're supposed to be unorganized, we're still not organized enough that we are the enforcement, because we're still dealing with the Bar Association. We're still dealing with the judges and the lawyers. You and I are supposed to be the enforcement. You and I are the ones who are supposed to be sitting down, putting down insurrection and rebellion. And these judges and lawyers, they are insurrection and they are in rebellion. They have overthrown our government. They have overthrown our system. They have embezzled our name. They have embezzled everything off of us out of our account under the bankruptcy. They've stolen our identity. They're doing human trafficking. What are you going to do about it? Ladies and gentlemen, we need to start getting a better understanding of what the laws are and how they're written and how they are to be applied. We need a better understanding. We need people to start joining forces and start standing up, and we need to start working together. We need to start backing one another the best we can. I'm giving you the best education. I'm telling you where this stuff is at. I'm trying to sit down and work with you people. I could be selling this stuff, but it isn't worth selling it. Donations, I'll take all the donations that I can get. Because it's my time that's being involved here to help educate. For those that want to donate, it goes back to P.O. Box 435, High Shoals, H-I-G-H Shoals, S-H-O-A-L-S, High Shoals, North Carolina, 28077. Ladies and gentlemen, we need workshops up on this. We need workshops up on the DIC Act. We need workshops up on driver's licenses. We need workshops up on the state of emergency. We need workshops up on child support. We can't do this. Can't do this all in one. We have to break this thing down per topic to give you 2-3 days to comprehend. But if you can understand the state of emergency, you understand that 1913 Federal Reserve Act, and you understand the state of emergency, where the president gave agencies the right to regulate, again, agencies, ATF, IRS, DOT, DMV, child services, your local county ordinances that come in for code enforcement. These are all agencies. Everything you're dealing with is an agency out of that state of emergency. Everything. You're not dealing with real people. You're dealing with an agency. And these judges don't want to admit this. Why? Because if you start understanding this, you've got them in fraud. Because you're not part of the administration. They can only regulate their own. They have no subject matter over the private citizen. These agencies were strictly for them and them alone. There's nothing in the DIC Act that allows law enforcement to have any type of weaponry on their hip, whether it's a pistol, whether it's a revolver, whether it's an AR, whether it's a shotgun. They are not entitled because there's nothing in the law enforcement in the DIC Act that allows them. It is strictly militia and militia only. That's your law enforcement, ladies and gentlemen. That's your law enforcement. Give it some thought about what we're talking about. Give it some thought. Because we got a lot of militia people out here. We got an awful lot of militia people. Go back and understand your role. Go back and understand your purpose, what your function is. Understand what your purpose and function. You're supposed to be in law enforcement. You have the authority for insurrection rebellion to put it down. And what are these lawyers, what are these judges doing? This is insurrection rebellion. What are these bankers doing? Insurrection and rebellion. They stole your identity. They stole your birth name. They're swindling your inheritance. They're swindling your trust. You want to fight these people? Get educated. Get knowledgeable. Understand what this stuff is. Learn how to come back in and apply it. Learn how to come back in and start getting organized. And start working in groups. So, ladies and gentlemen, this is the third segment I did here today. The first one was on 1913 and 1933 bankruptcy. The second one was on driver's licenses. This one was on the DIC Act of 1902. I'm trying to break these things down to hopefully give you a better understanding. Where with what you're looking at, you can go back and do a little bit of research and grasp what's being said. Ladies and gentlemen, I can only go so far. I can give you the information. You have to come back in and look it up yourself. You want to get some workshops up that I can bring it out and show you up on a screen, then you're going to have to get some workshops up. Otherwise, take what I'm giving you. Comprehend it. I've learned this stuff on the same manner as what I'm teaching you. I've learned how to go do my own research. I've got a research team behind me that's giving me a lot of information, but I still have to research their stuff. But ladies and gentlemen, the choice is yours. We're not trying to advocate anything here other than stick up for your rights. And don't allow them to violate their own rules and regulations, their own guidelines. And ladies and gentlemen, that is exactly what they're doing. They're violating their own statutory law when it comes down to you and I. They're depriving you and I of our rights under the Bill of Rights and under their own regulations that can only apply to them. So I've given you enough here and 3 calls here today for a basic understanding that everything that we're dealing with deals with agencies. It all comes out of that state of emergency under Section 2, that Public Law 148, Stat 1. Upon the banking issue or war or defense or state of emergency, the President can sit here and point to an agency to regulate. ATF, IRS, DOT, DMV, Child Services, all of this falls under the state of emergency. Comprehend this. Grasp it. Understand it. And the rest of this stuff will fall into place for you. The rest of it will go click, click, click. Fall right into place. Thank you. This is the 3rd show for today. I'll set some more up for a later date where we can get into some other issues. But we did 3 here for you guys to get back into. You all have a good day and have a good night. And hope you had a good Christmas and have a good New Year. Bye-bye. Good New Year. Bye-bye. Good New Year. Bye-bye. Good New Year. Bye-bye. Good New Year. Bye-bye.